Hello and welcome to my week 6 media presentation where I will be discussing the 4 ADRs for this week's material, as well as discussing each peer-reviewed article that I located on each ADR, and close it off by summarizing the news story that I located. So in the textbook, the first ADR discussed is early neutral evaluation, which is utilized in cases involving personal injury or for employment discrimination. And this is where the court assigns a third party who is neutral and they have to have knowledge on the issue. So this is usually a lawyer. The third party has to look at all possible outcomes if it were litigated in court. So preparation and presentation about the dispute does occur. The evaluator then has to focus on the agreements and assess the strengths and weaknesses of each side. But after that, after the decision is made, the parties can decide how to proceed further. But in the article by Norman Zaki, he focused on the potential that early neutral evaluation could have on complex civil cases. And the article is actually similar in the textbook because it actually encourages participation and communication, but it does expand by saying that this ADR works better in the earliest stages, so in pre-discovery, because the evaluator can actually have all the information early on and encourage the parties to agree mutually based on the information that he has and that he can disclose to both sides. So with this, the parties end up saving in cost because it would be resolved during discovery. The second is dispute review board, and according to the textbook, it is preferred for high risk and liability contracts for large civil infrastructure projects. So this is because there is a panel that is composed of experts led by an ADR professional, which is chosen by both sides. So the goal of this is for the experts to actually reduce the risk of litigation, but the success actually depends on if there's a well-developed contract for the project, and also if there's a baseline for project decisions, and if the issues are agreed upon. And lastly, if there are qualified experts that are knowledgeable and able to weigh the decisions based on the contract and merits of the argument. So in the article I located, it was similar to the textbook because it did explain the process, but it was more in depth, especially when it comes to choosing the members, and it further explained that there was a method which consisted of both parties appointing one member and obtain the other party's approval of that member, and then those two chosen members approve another DRB member, which is the third member in the selection. So the article explained that this is a method that eliminates both parties losing faith in their members during the process. Next is mini trials, which is costly but cheaper than litigation, and the textbook explained that this ADR is meant to enable two parties that are disputing to come together and voluntarily engage in a structured hearing over issues such as liability contracts, patent infringements, and employee grievances. And this ADR also includes a neutral party, and it explained that this is not a trial, but it is more of a form of a settlement process. So each party has to summarize their dispute, and they're encouraged to share information, which could also prevent escalation in dispute. And an article by Eric Green, he explained what was in the textbook by stating the purpose of this ADR, and it clarified that it is not arbitration but closely related because arbitration is more decision binding, while mini trials are more for advising. So the article expanded by explaining that the advisor listens to both sides' lawyers, but it can also conduct its own investigation, such as testing the potentially infringing projects of a franchisee. But if either side is withholding information, then the investigation ends. Lastly is summary jury trial, and according to the textbook, it can be completed in one day, and it follows the discovery phase, which occurs before a full trial. So jury members are brought in to make a decision on the dispute, but they are there as advisors, but they're not aware of it. If during this process there is no resolution, then it may go into a full trial, which allows for both sides to see how a potential jury may react to their arguments in front of a judge and a jury. In the article that I found, it paralleled information in the textbook because in the article it stated that this ADR is a pretrial arbitration or mediation because it participated in mock trials. So the article focused on points that made this ADR effective, which consists of fostering mutual agreements and mediation and preserving the relationship of both parties. The article expanded on this topic because it gave examples about various ways that the ADR could be applied. For example, it explained that this ADR is successful by stating that if all parties agree, then it increases autonomy among the parties. So if they're willing to be upfront about their information, then it encourages cooperative relationships in the future. And an empirical study found that parties who mediate through this ADR are more likely to abide by the results that is a mutual agreement. So the article that I decided to talk about is about AMC and the Walking Dead producers, who are Robert Kirkman, Gail Ann Hurd, Glenn Mazzara, and David Alpert, who are claiming that they have been cheated out of the money from AMC Studios because they claim that AMC had allegedly been undercharging the cable network for the rights to air the show, which means that they've been potentially losing out on money. So a judge in Los Angeles expressed that there would be a mini trial that would look into the contracts that were implemented. So the article further explained that the judge will listen to both sides so that the judge knows what needs to be addressed specifically and how long the process will take. So he plans to listen on both sides, what each side sees as an issue. The judge also explained that he hoped to resolve the issue with what is in the contract. So he hopes that it provides some form of clarity for the damages and to figure out a settlement. Thank you for listening. This is the end of my presentation. I hope I could have given some insight with my articles and news story. Thank you.